There's about two things that excited me in the ruling. Judge 21st October 2020. Namisindwa oye. Court process. This application is dismissed with costs to the respondents. I saw order. Second, empowered to refuse relief and deny access to the judicial review reliefs on ground of lashes because of several considerations. For example, it is not desirable to allow stale claims to be canvassed before the court. There should be finality to litigation. It cannot be argued that the Constitution intended to disregard all procedural rules in relation to access to justice, all grant of reliefs, and allow applications filed after inordinate delay. Constitutional provisions are not intended to supersede the available modes of obtaining relief before a civil court or deny the defenses legitimately open in such actions. The applicants, like all other litigants, should not be encouraged to circumvent the provisions made by the statute, providing a mechanism and procedure to challenge administrative action. Every potential litigant would rush to the court in any manner they deem fit, and thus rendering the statutory provisions meaningless and non-existing. Constitutional provisions are not intended to short-circuit or circumvent established procedures and statutory provisions for accessing courts, Article 126(2)(e). Every litigant who approaches the court must come forward not only with clean hands, but with a clean mind, clean heart, and with clean objectives. The court must come with a very heavy hand on a litigant who seeks to abuse the process of the court, as the Supreme Court of India observed. The case is listed. It is the responsibility of the High Court as custodian of justice and the Constitution and rule of law to maintain the social balance by interfering where necessary for the sake of justice and refusing to interfere where it is against the social interest and public good. This court declines to entertain the application since it was not brought under any known procedure, and secondly, it was made to avoid the time limit of 3 months within which an application for judicial review should have been brought. The judicial review guidelines or rules equally provide for locus standi, and this should have been the threshold before the applicants would seek to challenge the actions of a party. Applicants in this case ought to have applied for judicial review within 3 months after the change of the name of the party from NURP to NUP, that is to say by 6th June 2019, but instead the applicants filed this application on 24th August 2020 after 1 year. This application was made with the view of making some money during the election season, and the applicants have no genuine grievance, but rather want to be relevant and make some quick cash. Gombe have also been made applicants, and the judge has explained that in the ruling. So the respondents are the National Unity Platform, Kyagulanyi Ssentamu Robert, David Lewis Lubongoya, Aisha Kabanda, Joel Senyonyi, Flavia Kalule Nabagabe, Nyanzi Fred Ssentamu, the Electoral Commission of Uganda, and the Attorney General of Uganda. The ruling is by Justice Musa Sekana. I'll go to the G versus Manchester United. Yes.
This battle, we are winning the rest of the battles. We have therefore handed back the mantle to Ugandans out there. Fight your war. This is your war. And be strong, because this is a just war. We are fighting a just war. We are fighting a just cause. This is our country. We cannot surrender the country. We have no second home. I mean, those in government today have a second home. They have somewhere else to go. They have their red passports. They have amassed a lot of wealth. They have acquired homes outside. Others have homes traditionally. Thank you. May I invite you? If you want to know there is something abnormal about this country, just witness a struggle between Jajja Yoweri Tibuhaburwa Yeseri Museveni and this fat man called Sas Marvin. Surely, How do you have a contest between Sas Marvin and Tibuhaburwa? That is how unfair this country has become. I want to acknowledge all the participants and the contributions of all the lawyers that have assisted us in this struggle. There is one I deprived of this opportunity who should have been here, Jonathan Elotu. He was the coordinator. He would run between me and Lewis, the Secretary General. So, Mr. President, the last thing I want to say.
Can I go back?
Yes, the gentleman was seeking permission to go back and he's permitted. And that is what it should be. Mr. President, the struggle is not over. But this was a struggle against the people of Uganda. The people of Uganda continue in the struggle to break the chains that have enslaved them in their own country. I do not want to say much. We agreed as a legal team to present this ruling formally to you and the party, but through you and the party, Mr. President, to the country. Because this case came up and was crafted to intimidate our forces of change. In particular, some of our contestants who had been dissuaded to think that if you nominate on the NUP ticket, then the next day the party will be no more, and quite a significant number pulled out of the race, others returned or shelved our ticket because they thought the party was coming to an end. Now, this is a struggle for the brave. I therefore want to congratulate those that have remained brave and committed to the cause. Thank you and congratulations. May I now invite my brother Anthony Wameri, and everywhere, Mr. President, in our midst, and the Deputy President for this region, and your entire cabinet and lieutenants and generals present, all our field force commanders and soldiers, it gives me great pleasure to present the judgment and decision of the High Court of Uganda in this landmark case. First, to the legal advisor, who is the head of the docket, to you, Your Excellency, and the entire country, because everybody is glued onto the television to receive this. As team leader, I was only given the assignment of leading the forces that I seek your permission to introduce. First, our Secretary General, David Lewis, Ubongoya.